It is the appointed time for the meeting and we have a quorum. Shall we invite the administration team and also representatives of the Competition Commission to come in?
I'd
like to welcome representatives of the Judiciary and also the Competition Commission. Since the last meeting, I understand that the DOJ, or actually the Judiciary, sent in 2 papers in order to respond to queries raised at the last meeting. I'd like to ask Ms. Wendy Zheng to take us through those 2 papers, please. Yes, thank you, Chairman. As you said, Chairman, at the last meeting, members asked certain questions, and in the first paper, in response to members' request, we have now included the comments of the Bar Association and the Law Society on the draft rules for the Competition Tribunal, and also the Judiciary's responses. I don't think I should go into the details today, but in general, the Hong Kong BA supports all the draft rules submitted to Leg.on, and overall speaking, the Law Society also gives its support. And all the views raised by the Law Society have been responded to. I'd like to ask whether members have particular views or whether you would like me to comment on any particular point. I think the Law Society has raised certain views and you have responded to those. I understand not all the views have been supported by the administration. Can you not show us where you do not agree and why? I think one of the issues is the right of audience. The Law Society said that they would hope that solicitors should be given the right of audience as barristers at the Competition Tribunal and enjoy the right of audience there. We explained in detail that since the tribunal is a higher court of record, in other words, it is equivalent to the CFI of the High Court. And in 2009, when we amended the Legal Practitioners Ordinance, we arrived at a consensus that not all solicitors should enjoy the right of audience in the High Court. They must attain certain qualification so that they have the advocacy qualification before they can enjoy that right of audience. I remember there was a lot of discussion, a lot of consultation in order to balance the different interests of barristers and solicitors, and a consensus was reached. We understand that the Competition Tribunal is in a way an extension of the High Court, and therefore the right of audience should be similar as that for the High Court, and that is why we did not accept that proposal. Actually, last year, when we amended the competition ordinance, we again took the issue to the Bills Committee concerned. At that time, there was an amendment proposed also to the Legal Practitioners Ordinance as a consequential amendment, and we made the amendment so that the right of audience for solicitors will be reserved for those who have attained the advocacy qualification. I understand. What if it is heard in chambers? Even if solicitors do not have the right of audience at the High Court, they can still represent clients if the hearing is heard in chambers. Yes, whatever is done at the High Court now, the Competition Tribunal will do the same. I'd like to ask the Competition Commission later on if you should bring cases, and then if there are in-house lawyers at the Commission, would they also represent the Commission at court, and what will be the arrangement?
Thank you, Chairman, for the question. I think in terms of how the Commission might represent itself in the Tribunal, if, of course, we had lawyers internally with the requisite rights of audience, then potentially we would take that avenue. Failing that, we would plan to instruct counsel, barristers, to represent the Commission in the Tribunal.
And you have the budget needed to instruct external counsel if necessary, or is that something that you would like to see more support provided for the Commission?
No, we have a budget allocation for that purpose.
Okay.
Ms. Zhang, please continue. Thank you, Chairman. Well, perhaps I will now go through the second paper. The title of the paper, which is only in English for the time being, whether there are further streamlining of procedures for follow-on actions. Now, last time at the meeting, members raised some questions and make some comments on follow-on actions, and the Judiciary has issued a paper, and may I walk members through the paper. Now, something about the background. Section 110 of the Competition Ordinance provides for follow-on right of action, and a person who has suffered loss of damage as a result of any act of contravention of a conduct rule has a right of action called the follow-on action against such person. And we should not underestimate the complexity of such follow-on actions for the following reasons. First of all, the variety is great. For example, there could be damage of claims at the CFI in which the liability is not seriously in dispute. However, there may also be cases in which there could be legal factual disputes, and also which may be difficult to determine in respect of larger claims. And also, a company may not be sued by consumers for buying goods at a price higher than the competitive price. Very often it will be a claim by a business entity against another commercial entity. Thirdly, even if the tribunal has made certain finding of facts on the contravention, it doesn't mean that the liability has been resolved in a follow-on action, because the defendant can still raise a defense to the extent that the conduct did not cause the loss or damage suffered by the plaintiff. And these are inherent difficulties in commercial litigation, as well as competition litigation, which cannot be overcome by procedural simplicity. And fourthly, even where causation is not in dispute, the plaintiffs are still required to provide the precise extent of their loss and quantification of loss in monetary terms. In short, in relation to the extent of loss or liability, or these matters have nothing to do with the enforcement process between the Competition Commission and the defendant. It is therefore not possible to deal with such matters in the follow-on action stage, and it is equally not enforceable. So earlier, some members suggested that a list of victims could be drawn up by the Commission at the enforcement stage or by the tribunal. We do not find it appropriate. Secondly, now, in determining the procedures for follow-on actions, the Judiciary the tribunal should conduct its proceedings with as much informality as is consistent with attaining justice. However, information should also be provided for fair disposal of the case as soon as possible. And bearing in mind these principles, there are two major principles. First of all, as set out in the paper, we should ensure that information should be provided to the tribunal as soon as possible to prevent any delay in the proceedings. But against this backdrop, we'll also try to simplify the procedures and minimize the information sought. Secondly, we believe that the tribunal should be provided with adequate powers to, depending on the complexity, nature, and claim amount of the case, adopt different procedures to expedite the follow-on cases as necessary by adopting the different procedures. And may I elaborate on these two principles? First, on simplifying procedure and minimizing information sought. For example, in Part 5 of the CTR, we have proposed the use of forms to enable litigants to set out their grounds of application. We believe that this will help reduce costs. And at the last meeting, members suggested whether Rule 93 and 94 of the CTR could be consolidated. That is, in short, whether Form 8 and Form 1 can be combined, or the information required under Rules 93 and 94 can be combined. Now, may I briefly explain the objective of the applications made under Rule 93 and 94? They're different. For information required in Rule 94, before the conclusion of the proceedings, if a plaintiff would like to claim a follow-on action, then Form 1 is required, and the main concern is about timing. So the information required is likely to be brief. As for information required in Rule 93, more information is required because this is about the follow-on action itself. For example, the information may be about the basis of the claim and the amount of damages sought. So the information required may be more detailed. So we've considered the member's suggestion as to whether these two forms can be combined, and we don't believe this is appropriate because we are concerned about the front-loading of costs. So, for example, after combining the forms, the litigant will be required to submit in great detail all the information required under Rule 93, although the court or the tribunal has yet to given leave for the proceedings to be brought earlier than usual. So we don't propose to combine the two forms. The second principle is to provide the tribunal with adequate powers. Well, last time members suggested that the judiciary should consider whether the tribunal should be given more powers to expedite its procedures as necessary. And we agree that the tribunal should be provided with adequate powers to flexibly handle cases of different complexity, nature, and claim amounts. And in fact, according to the draft CTR submitted to Leg.on, in 5 areas, we have proposed the following powers of the tribunal. First of all, the tribunal would have a lot of room to be flexible under the draft CTR. For example, the use of summary judgment to reduce costs. And also, after the initial rounds of submission of information, the tribunal may decide on the best procedure by holding a direction hearing, so that the tribunal may consider the best procedures to be adopted. Thirdly, depending on the circumstances, the tribunal is given the power to dispense with the application of the rules of the High Court. And fourthly, even in the case of non-compliance, the tribunal needs not hold any proceedings to be void. And finally, the tribunal may also, on invitation or on its own motion, consolidate cases. And we reviewed the above powers as per members' suggestion, and we believe that these powers are already adequate for the tribunal to expedite the procedures for follow-on actions as necessary, depending on the complexity, nature, and claim amount of the case. And in fact, according to our experience at various levels of court, including the CFI, the litigants in person are largely able to follow the requirements of stating their cases in the claim form. And when they have difficulties, the court may help them, and the tribunal would do the same. At the last meeting, members also suggested further simplifying the procedures for follow-on actions, and based on the analysis mentioned above, we believe that the room for further streamlining is quite limited. However, as for members' concerns, we again review Rule 93 and see whether there is room for further streamlining of procedures. Para 7 of the paper proposes an amendment to Rule 93 such that when the plaintiff has no commercially sensitive information for disclosure, then the originating notice of claim, that is the Form 8 of the schedule, may be combined with a statement of claim required under Rule 93(1)(b) under appropriate circumstances. And the proposed changes of the form are and a change of the Rule 93 are the annex. So, subject to members' agreement, such changes will be incorporated in draft CTR. Thank you, Chairman. Any questions from members? Legal advisor. Thank you, Chairman. Chairman, in relation to the proposed changes, as mentioned by Ms. Cheung, in para 17, the administration provided in its annex the proposed changes. Now, we should note that according to Ms. Cheung, the proposed changes are as follows. That is to say, one may bring a follow-on action under Rule 93(1)(a) or (b), and for 93(1)(a), an originating notice of claim in Form 8 should be submitted, and the Form 8 will already be endorsed with a statement of claim. And under 93(1)(b), however, there will be a separate statement of claim. As I understand, under footnote 5 of Form 8, it says that a separate statement of claim is required if the plaintiff wishes to maintain the confidentiality of any information contained in the statement. However, we should note that for the proposed Rule 55 and 56 in relation to right of parties to inspect certain documents filed in the tribunal, that is about inspecting originating documents. And if we look at Rule 2(1)(a), and I quote, originating document means a document by filing of which proceedings are commenced in the tribunal, and that is A. So that is to say, the first document submitted to the tribunal for the initiation of proceedings is called the originating document. And if the applicant is required to submit the Form 8 together with a separate statement of claim, then would both documents under this definition be regarded as the originating document, such that the public, on inspection of originating documents, would have access to these documents? And I understand that as far as the operation of the CFI is concerned, only the first originating document would be available for public inspection. So that would mean that only Form 8 should be made available for public's access. But if the document or the separate statement of claim should be regarded separately for confidentiality's purpose, then it should not be made available for public's inspection as an originating document. I wonder if the draft could truly reflect this intention. Perhaps the administration should go back and consider whether further amendments to the rules are required. Thank you, Chairman. Thank you, Legal Advisor, for your suggestion. Now, as the Legal Advisor mentioned just now, we understand that as far as the practice of the CFI is concerned, be it a writ or the covering, this will be something that the public will have access. Whereas for other detailed submissions therein, they will not be made available for public's inspection. So this is the established practice of the CFI. The legal advisor has just raised a point in drafting that is for greater clarity. We may make amendment to the interpretation of originating document in Rule 2. We may consider defining what is meant by originating document and what is not. I agree with the legal advisor because any person present wishing to inspect documents at the High Court, then at present, indeed, there is a confusion as to the definition of originating documents. So according to your version, the public can inspect Form 8. But if the Form 8 doesn't come with a statement of claim, then the public will not be able to inspect that. Well, but with the court's leave, the public can. So there is a hurdle to go through. But as far as the actual operation is concerned, it's up to the applicant to decide which avenue to take.
Sometimes he may like to think whether there is confidential information, and it is up to him to decide. Is that right? Yes, this is the arrangement for the CFI. It is up to the applicant to decide whether he wants to keep something secret. So the flexibility lies with the applicant. All the amendments proposed are to afford flexibility. If someone thinks that there is nothing to hide and someone actually may think that he wants everything to be known, then he can make use of Form 8 and submit the information at one go. But if he has worries, then he can do it separately, and the public will only be able to get Form 8, not the statement of claim. I understand. But you can certainly consider the view advanced by the legal advisor and clarify the wording and to state what can be inspected and what cannot be inspected. Yes, Chairman, thank you. In the annex, we have only provided a proposal in principle, but because of time constraint, we have put forward this amendment in a rush. But in terms of drafting, we are going to do continuous improvement. Okay. With regard to this new amendment, any questions from members? The Competition Commission, would you like to comment on any point? If not.
Okay. Thank you.
Okay. Next time, after studying the issue, if you have further proposals, please bring them back to the committee for discussion. Okay, Ms. Chung, would you like to supplement these two papers? I have nothing to supplement, Chairman. Okay. Now I'd like to invite the Competition Commission, because I understand it has written a letter to the committee dated the 30th of March 2015.
Again, to explain the contents of your letter dated the 30th March 2015.
Thank you, Chairman. Yes, during the last meeting of the subcommittee, a question was addressed to the Commission as to whether we could provide legal assistance to claimants under the ordinance wishing to file a collective claim in the tribunal with a view to reducing claimants' legal costs. The first point here is, of course, we don't have a statutory function of providing legal advice to would-be plaintiffs, and moreover, any advice that we might seek to provide would not be protected by legal privilege. That said, there are, of course, a number of things we can do to help claimants seek compensation. And I think the key word is compensation, because there are a number of different ways claimants can seek compensation, and follow-on damages actions is one possibility, but there are others, as I'll explain in a minute. As Ms. Chung has explained, follow-on action is provided for in the ordinance. There is no possibility of standalone action. Parties cannot sue unless the Commission has first taken a case against parties and the Tribunal has established that there is a contravention of the ordinance, or if a person has made an admission in a commitment which has been accepted by the Commission that the person has contravened the competition ordinance. In that circumstance, it is also possible to take a follow-on action. In a sense, the fact that the Commission has to establish an infringement first before the tribunal, that is a mechanism which relieves the plaintiff of the burden of establishing that there is an infringement. So to that extent, the ordinance has an inbuilt mechanism which reduces legal costs for plaintiffs. They are left to establish the issues that they are best placed to establish, causation and damages. Of course, parties can make a complaint to the Commission if they are concerned by anti-competitive conduct. And the Commission can, in addition, of course, to seeking a financial penalty or otherwise resolving its concerns with the contravening party, can seek different types of orders from the tribunal. So financial penalty is one possibility, disqualification of directors is another, but the Commission can also seek an award of damages for victims and I use the term damages here loosely to include also the possibility of restitution or other compensation. So it is possible under the ordinance for the Commission to seek those sorts of remedies on behalf of claimants, if you like, that obviates the need for the claimant then to take the follow-on action. Not every case would be appropriate for that sort of remedy. Certain cases would be more appropriate than others. We could seek that sort of remedy in the original proceedings to establish an infringement, whether they are contested or whether there are consent proceedings. We might agree with the contravening party that they should make some sort of restitution to claimants. Similarly, we might, in the context of an immunity agreement that we would conclude under Section 80 of the Ordinance with a contravening party, we might impose a condition of restitution of some kind. Now, I say that with paying attention to the fact, of course, that we have not yet firmly finalised our leniency policy, but that is a possibility that we could consider. In any event, when we do finalise the leniency policy or the immunity policy, we will have regard to the fact that that policy should not function so as to preclude claimants from seeking compensation for their private losses. In addition to the sorts of compensation or restitution type remedy that we might look for, overseas jurisprudence provides examples of that. In Australia, for example, the ACCC, or the Australian Competition Authority, can seek compensation on behalf of victims. In the US, the Department of Justice can seek restitution on behalf of victims, and indeed restitution was ordered in the recent air cargo cases. Certain airlines had to make restitution as part of their settlement with the Department of Justice. There are also possibilities for more novel arrangements or more experimental arrangements, if you like, depending on the facts of the case. We might seek an order obliging the contravening parties to establish a fund which victims could make a claim on, and that sort of mechanism has been used in the United Kingdom in a recent case concerning the fixing of prices in respect of private schools. The schools were obligated to establish and run a fund that claimants could draw on. So those are different ways of lowering the cost, in a sense, for claimants. Whether one would choose to pursue those sorts of remedies in a particular case would depend on a number of factors, but one factor clearly would be whether the victims concerned were likely to take follow-on action or whether they were not well placed to do that. That would be a consideration in terms of whether you would pursue this sort of remedy. Equally, you would have to look at the facts of the case. For restitution, you'd need to be able to determine how much money had been earned by the contravening conduct, what profit had been made, and you'd need to be able to do that with some precision, and you'd need to be able to determine who should get what proportion of the profit. So there are certain factors which would favor that sort of remedy. In addition, of course, we have a general policy of promoting or publicizing the outcomes of our cases, and that means that parties will know whether an infringement has occurred and whether there is whether they might have a right to seek some sort of compensation. We could certainly in that context encourage the victims or potential victims to discuss together in terms of assessing whether they might want to consolidate or work together in terms of seeking a claim, and that might lower legal costs. Or we could encourage a dialogue with the contravening parties, and that might allow for a settlement and compensation without having to resort to a follow-on damages action. Of course, the Commission would also have in its possession, following its investigation, evidence of the contravention, potentially evidence concerning the actual harm that victims suffered, and all of that evidence would be, certainly most of that evidence would be available to claimants through the discovery process. Finally, in terms of the Commission's possibility to get involved in follow-on actions itself, we can intervene in those sorts of actions. We don't yet have a policy as to what sort of cases or where we might intervene, but relevant considerations might be whether there were important legal questions that needed to be answered, whether perhaps there were arguments around disclosure that we had a particular interest in, or indeed questions concerning the calculation of damages. There may be questions where we would be well placed to offer a view, having already undertaken an assessment of the harm caused by the contravening conduct in our prior enforcement proceedings. And that summarises the content of the letter, Chairman.
Okay, thank you. 有冇委員有問題?
Any questions, members? Legal advisor. If members have no questions, I think we can go to the next stage, and that is clause-by-clause examination of the rules. I understand that the Judiciary will or may propose other amendments, but I don't think that would debar us from starting the clause-by-clause examination of the rules. Chairman, depending on whether Ms. Zhang will agree, should we start with the CTR? And that is Annex A attached to the paper submitted today. With the Chairman's consent, I am obliged.
Mr. Marnican, we are going to go to our next stage of scrutinizing the provisions by provision of the rules. You don't have to stay, but you're more than welcome to stay if you want to. And if you need the documents, I can ask the Secretary to provide you with a set of the draft rules.
I have the documents,
but
I can stay if you wish, Chairman. Sure. I'll leave it to you.
Okay, that would be great. 張女士，麻煩你開始。
Ms. Zhang? Let's go to Annex A. Rules of the Competition Tribunal. The first one, commencement date. These rules come into operation on a date to be appointed by the Chief Judge by notice published in the Gazette, and we expect that to come into force on the same day as the ordinance. Second, interpretation. I won't go into the details, but then as the legal advisor said, we may refine the interpretation of originating document. Number 3, sorry, Ms. Zhang, please wait. Legal advisor, thank you. With regard to Clause 2 interpretation, actually we wrote a letter to the Judiciary earlier on asking certain questions, and that's in paper 739/01 And Ms. Zhang has already responded to the paper in writing. And under 2.1, one of our questions was about party. We can see that under A, it mentions an intervener. We are aware that in these draft rules, in both 20 and 21, it says that with leave, these people can intervene into the court procedures, and also the Competition Commission can also intervene under Clause 21. From the drafting point of view, we'd like to ask about the interpretation of A, an intervener, under party. We'd like to know whether you mean to include Clause 20 and Clause 21, that is including the Competition Commission. And then under B, it says an interested party, and it mentions Rule 64. We'd like to seek some clarification, and that is under A, you can mention Rule 21 and also Rule 20, as you do for B by mentioning Rule 64.
Ms. Zhang, thank you, Chairman. The concept of intervention is actually provided in Section 120 of the Competition Ordinance. So this is not a new concept as far as intervention is concerned. I think the legal advisor raised a point about drafting for better clarity and accessibility, and we'll go back and consider amending the definition of an intervener. But of course, we have to be careful. Well, now the intervener includes the intervention by Commission in Clause 21. That is, the Commission can apply for leave to intervene. This is also included in the term intervener in point A. Yes, any intervener or the Commission. So perhaps you should make it clear that an intervener includes the intervention by a party in Clause 20 as well as 21. Yes, please continue. Clause 3 is about application of these rules. This part in Part 2 applies to all proceedings under the ordinance, and Part 3 applies to an application for a review of a reviewable determination, and Part 4 applies to enforcement of a commitment, and also Part 5 applies to an action brought that is a follow-on action under Section 110, and Part 6 applies to all proceedings transferred from the CFI to the Tribunal. Clause 4, application of RHC. There are two parts. Part 1, where the ordinance of these rules make no provision for a matter, the RHC apply to all these proceedings as far as they may be applicable to that matter. This is to avoid copying a substantial part of the RHC to the CTR. Subsection 2 or subsection 3 in relation to despite Rule 1, the Tribunal may dispense with the application of the RHC under circumstances, for example, to save costs or to do it in the interest of justice. Yes, please pause here. Thank you, Chairman. About Clause 4, as we mentioned in the letter to the administration, we raised a question. 4.1 says that where the ordinance and these rules make no provision for a matter, the RHC apply to all proceedings. So, in other words, our question is as follows. Now, for a matter, if there are provisions made under the CTR and the RHC, does it mean that the CTR should prevail? And the administration gave an explanation in detail, illustrated in examples. Perhaps Ms. Zhang can walk members through the explanation. Yes, in short, whether provisions in the CTR, they should prevail. Because the provisions are only included in the CTR because they are necessary. So under normal circumstances, the CTR should prevail. However, there are some exceptions. In para 9 of the paper, it says partial application. That is, some provisions in the RHC would have to be reapplied, and we'll make it clear. For example, well, if members are interested, we can refer to Rule 15. That is, that a certain order under the RHC would continue to apply, and this will be expressly provided. We adopt this approach to avoid copying a substantial part of the RHC, and we also like to, at the same time, be able to streamline certain procedures. All right, understood. Is this common? I mean, where there are conflicts between the RHC and the CTR, or duplication? Now, all the differences are set out in the CTR. I mean, in general, the RHC can still apply to these proceedings, despite that there is no such provision in the CTR itself. All right, Rule 5. Rule 5 provides that the tribunal may exercise its powers either of its own motion or on application. Rule 6. Rule 6 provides, unless otherwise directed, non-compliance with any of these rules will not render any proceedings void. Rule 7. Unless otherwise provided in this provision, all proceedings before the tribunal must commence with Form 1. Rule 8. Interlocutory application. And that a summons in Form 2 should be filed, and the interlocutory application should be made for the notice to be served. Yes, please pause here.
Okay.
OK， 好，跟住係第9條。第9條咧係賦予
Rule 9. Under circumstances, the tribunal may consolidate some cases. For example, if it appears to the tribunal that some common question of law or facts arises in all of the cases, etc., for the purpose of reducing costs. Rule 10. Forms. It provides that forms may be modified or varied as the circumstances may require. Rule 11, about service of documents. And for the first document, the party must provide the party's address for the document to be served. And Rule 12, the document must serve the document on other parties. Rule 13 is about service of originating documents. For example, it should be served by person, and also there are requirements on the method of service and time. Legal advisor. On Rule 13, there are 2 points in the Chinese text. For Rule 13, Sub-Rule 3, the first sentence is in bold, so it should be amended when it is gazetted. And as for the other point, Rule 13.8, we wrote to the administration for clarification about substituted service. Our question is this: if a party would like to apply for an order, what should be the method? Should an affidavit be filed to support this application? it seems that these details are not set out in this rule. And we also ask whether the RHC's relevant order, that is Order 65, applies. And according to the administration's reply, Order 65 does not apply. So what should be the method of application, Ms. Zhang? As we mentioned in paragraph 13 of the response paper, the party should first apply for an order for substitution service. It should be supported by an affidavit. As for Order 65 or Rule 4 of the RHC as quoted by the legal advisor, this is not for originating documents, so this doesn't apply. We also considered legal advisor's point whether Rule 13.8 is not clear enough as far as the procedure is concerned, and we would consider to include the filing of an affidavit as a requirement under Rule 13.8. But under the existing Rule 13.8, if substituted service is required, then the party should apply for a direction from the tribunal and for the party to act in accordance with the direction instead of following the usual procedure. As I understand, the party should apply to the High Court first, and then a leave may be given for the an order would be made on the form of service, but we believe that if necessary we can clarify this rule. So Ms. Zhang, go back and think about this. Clear this up. All right. Rule 14. Provides that Order 65 of the RHC applies to a document other than an originating document required to be served. Rule 15 sets out the notice to be given by tribunal, for example, by post. Rule 16. With leave of the tribunal, document may be served out of our jurisdiction. Rule 17. The person on whom the document is served is not required to acknowledge service of the document or to give a notice of intention to defend. This is different from the RHC as the purpose is to streamline the procedure. Rule 18 is about duration and renewal of originating documents. Normally, the originating document served is valid in the first instance for 6 months, beginning with the date of its filing. If there are no questions, then Rule 19. 1. The registrar may publish a notice in a manner that the President may direct as soon as practicable for the relevant parties to intervene as soon as possible, and all the notices required are also set out in Rule 19. Yes. Rule 20. Rule 20 is about intervention by a third party other than the Commission, who has a sufficient interest in the matters. And if the tribunal is satisfied, leave may be given for the party to be an intervener, and the tribunal may also give direction on the extent of participation by the party. What qualifications would be required? Who can be qualified as an intervener? Or is it the case that any person can apply to become an intervener? Thank you, member, for the question. Now, here, it provides that the person should have a sufficient interest in the matters to which the proceedings relate. That is, in short, the court will consider the person applying for intervention, whether the person has a real or insufficient interest. For example, the Commission may be suing supermarket A for anti-competitive conduct, and we may have reason to believe that supermarkets B or C may also be engaging in the same kind of conduct. And in relation to the case, these supermarkets may have a sufficient interest. So when supermarket A is ruled to be anti-competitive, it is likely that supermarket B and C will be affected as well. So I think the law will develop and make it clearer who is meant by a person with sufficient interest in the matter. Well, using your supermarket example, is a user of any of these supermarkets somebody with sufficient interest?
I'm talking about consumers. Ms. Zhang, Chairman, in Rule 19G, this term, a person who has a sufficient interest, well, this is used in many other places in our laws, and the law is still developing. It's very difficult for us to give a hard and fast definition because cases do vary. We have to see how the case law here will develop. But we do not rule out consumers and whether they can become people with sufficient interest. We do not rule out that possibility in law. Under G, you don't actually explain what it means. 19(2)G. Yes, that is one of the places where this is mentioned. You just count the days there. What's the legislative intent and who do you have in mind? Of course, we can leave it to the court, but then you do have an objective when you draft the law. Do you intend to include consumers? If necessary, I can ask the DOJ to comment, because right now, the court may have already interpreted sufficient interest. The DOJ? Chairman, let me explain the term sufficient interest. It is actually a loosely drafted term and is very difficult to define it because it depends on the circumstances. In some judicial review cases, the court ruled that some people were people with a sufficient interest, so they could be a party to the case. But as to whether there is a hard and fast definition for this term, I can say there is none. We can only gain some reference from case law. There is no definition as to who is a person with sufficient interest. Then I'd like to ask, in jurisdictions where there is competition law, I believe they also have this concept of intervener. And what is the threshold for those jurisdictions? Do you have the information about other jurisdictions? Chairman, we do not have the information at hand. I think we need to go back and do some research. Well, my understanding of Mr. Guan's remark is that in judicial review cases, the court will look at the background of the case and the scope of the case to decide whether a person is a person with a sufficient interest so that he will be allowed to participate. As Ms. Zhang said, in Hong Kong, as a jurisdiction, we still have no case law which can help us delineate who is a person with sufficient interest. We need cases to develop. I know that. But then when we make laws, should we leave everything to the court, or at least we should somehow have some legislative intent? You must have an idea how big the scope you intend to be. We know we have judicial independence, but at least you have to have a certain scope in mind. And if the legislators will learn that the court may think it is too big a scope, then we can have some basis to narrow it. But it seems there is no basis for discussion now. Chairman, as we said, under Rule 20, Para 19 in the paper, we said that we would like to leave some latitude to the court to make a decision as to who is a person with sufficient interest. But our primary thinking is that these people should have an interest which is directly related or connected with the subject matter of an action or application. We are talking about a direct interest. This is the intent. Well, okay, but when a judge interprets this rule, if I am a consumer before the court, would I be regarded as an intervener? Or, well, this is a common sense question. It's not a question of rocket science. If you can't even answer this question, can you not clarify the construction? Ms. Zhang, you have heard Mr. Sin. Please avail yourself to other jurisdictions with competition laws to see whether there is any room for making this even clearer, or at least answer Mr. Sin's concerns. Let me just reiterate. We do not rule out the possibility of including consumers. Well, I know, but if you ask me, if consumers cannot intervene when they want to, then I would say that the scope is cast too narrow. And if you say it depends on the court, then if the court says no to consumers, then I would say the scope is too narrow. This is my stance, but other members may disagree. At least I state my view here. I believe at least you should state who will be able to intervene. And it's not just about procedures, but legislative intent. Legal advisor. Thank you, Chairman. As Ms. Zhang said, maybe the administration can go back and look at whether the same construction is used in laws in other jurisdictions. And in fact, the administration provided an earlier paper. That is the Competition Tribunal Rules 2003. You mentioned the intervention procedure during appeals, and in that paper, under 16, you say that a person with a sufficient interest can apply to intervene. So maybe you can go back and see whether a similar term is used in other jurisdictions, and also whether there is case law in other jurisdictions interpreting the person with a sufficient interest vis-a-vis competition cases. Okay, that will be some great assistance for this committee and to take care of Mr. Sin's concerns. Thank you, Chairman. Just a small point. This term, sufficient interest, is actually in Section 85 of the Principal Ordinance. We understand the members' concern. We will go back and look at other jurisdictions and how they do it. Okay, at the next meeting, we can revisit this point. All right. If no other questions are asked under this one, we can go to Rule 21. Intervention by Commission. The procedure will be the same for the Commission as for other applicants. Rule 22, addition of parties, as decided by the tribunal, that they can allow any person to join the proceedings or in substitution of any party to the proceedings. Sorry, the speaker's not coming through. Sorry. Some explanation. Can I defer to the DOJ? Intervention. it means that you are not originally a party to a suit, but you think that the situation or the judgment on the case may affect your interest, then you can apply to intervene. That I understand. What do you mean by a substitution of? This is my question. Where are we? Substitution means if another party may not be well suited to be a party, then you can apply to the court to substitute that party to be a party to the suit. Chairman, please pardon my background. I'm a layman here. I would be the plaintiff, but then suddenly I would be substituted and I am no longer a plaintiff. Would that happen? No, I don't think that is the meaning. By substitution, it means that maybe a party's status has changed. An example will be originally it is a party to the suit, but then the person, for example, may die in the process and he must send in a substitute. In that case, an application has to be made to the court so that this person will become a party to the suit. You are not the original applicant. It is not that I think you are not a suitable applicant, so I apply to substitute you. That's not the meaning. Maybe it's because that person's status has changed. Is this common in law cases that people are substituted? No, it is not a common phenomenon, but it happens. It happens, but it is not common. Why is it not common? Since it is not common, why do you want to add this in this rule? I believe it is because if indeed such a situation should arise, we can take care of it, because there will be backing in the law to tackle such a situation.
Okay.
I am still not okay. If this is common in civil cases, and if this is allowed, then does it mean it should be in the rules? Is it that if this is not in the rules, then there will be no such power? Well, I believe this will help to clarify this rule if this is put in. My last question. Is it that the following situation will never appear? In other words, the plaintiff is substituted by another. My understanding is that this will not happen. I cannot imagine such a situation arising. But if you say, I think a party is not that suited to be a party, I cannot apply to substitute him, but I can apply to participate, so we can have addition of parties. Well, I have no problem with addition. I have problems with substitution, and I can explain why. Now, somebody should have the power or status to be a party, but here you allow people to substitute him. Well, but as I said, substitution usually happens when a person dies and another one replaces him to take care of litigation. I don't want to limit you, but if you say a party cannot discharge his duty or use his own rights, then I can understand that prerequisite. But this is not in the rules, and I don't understand why in any circumstance somebody can be just substituted by another. Well, I don't think that is the case. when you apply to substitute a party, you must have enough justification to prove why you can substitute another.
OK，仲冇嘢補充？
Anything else? I'd just like to say, actually, in the RHC Orders 15(7) of the RHC, it states that if somebody dies in the process, the person can be substituted. So this happens with the CFI. Well, that I understand, but this is exactly my concern. If RHC already regulates this, and if I do not have 22(1), then I believe the RHC, as quoted by you, will apply here, since there is not another rule in the CTR. But now that you have this in the CTR, then you do not apply the RHC, right? If there is something in the CTR. You already mentioned the RHC, which caters to the case of deaths. But actually in 22(2), it says Order 15 of the RHC applies. In other words, that cause of substitution can be applied here.
So, if you have Sub-Rule 2, why do you still have Sub-Rule 1? Well, we want to clarify the relationship between the intervener and the other party. Because when we draft the rules, because we have Rule 21 and 20, the DOJ's advice is that it may be a bit confusing, and Rule 22 therefore seeks to clarify the relationship between Rule 20 and 21. Well, I don't know whether it is the intention that somebody first of all becomes a plaintiff, and then the Commission can now intervene by becoming a plaintiff and substitute the original plaintiff because it is in a stronger position. Can you give me an example? Because when you say you want to clarify Rule 20 and 21, I get more confused. So do give us an example about substitution. Because when you always talk about somebody becoming deceased, and then Order 15 of the RHC already applies. So if this is the reason, then you don't even need Rule 22, am I right? Apart from the plaintiff becoming deceased, there may be other circumstances. For example, you may authorize another person to take up the case for you, and you can apply for the other person to substitute you. And for example, a person may be incapacitated. For example, maybe mentally the person is no longer capable of fulfilling obligations legally. Then another person may be entrusted to take up these duties on his behalf, and such applications may be made for the original plaintiff to be substituted. Yes, I understand that. What if there is a lawsuit between two parties? And will the other party be able to apply for substituting me with somebody else? I mean, I can understand an application made from my side or by me, but here it doesn't say who should substitute who. I think in the whole process, the court or the tribunal plays a role in deciding who should make the substitution. The court will look at who applies for the substitution and who should be substituted. So the court or the tribunal has a role. So we're in the process of enacting law, right? And we should consider who should be eligible for making this substitution application. We're talking about who's making the serve in the ball game. Because if the application can only be initiated by somebody on my side, then I feel more comfortable, because this may be my wish But I wonder if there are circumstances in which I may be substituted against my wish. And that's my concern. As I mentioned just now, the court plays a role. You apply to the court, but it's up to the court to accept the application. Yes, I know. The court will have to make a decision. But when we enact a piece of legislation, we should clarify these matters. I mean, should we? Do we need to? Or is it your original legislative intent that any person can apply for substitution? Now, from the point of view of litigation, any person should be able to do that. Similarly, any person can file a claim. But of course, it's up to the court, when the case is taken to the court, to decide whether you can really file a claim as a plaintiff. So this is for the court to decide. Well, but this is too wide. It's not about any person suing another person. Now, I'm talking about not just anybody, perhaps a person who has sufficient interest. Let's say if I am working on it and then somebody applies for me to be substituted, all of a sudden, then do I have the right to object to the substitution application? Well, if you read the rules, you can see that the tribunal will determine on the application. And a person cannot just come in and substitute another person. The person must first apply to the tribunal for substitution to be made, and the tribunal will hear from both parties, not affected parties, before coming to a decision. So you cannot unilaterally substitute another. Am I correct? Yes, Chairman.
Well,
let's see if you have something else to add next time to allay Mr. Sin Chung Kai's concerns. If necessary, you can supplement information to address his concerns. Legal advisor. Yes, perhaps the administration can also provide more information on this. Perhaps to make a comparison between this and the procedures at the civil proceedings of the CFI. For example, when Order 15 of RHC should apply, whether it's a person who has deceased or what, and we can have a comparison between the RHC and the CTR. Yes, we can go back and find out the relevant information. Yes. Let's see if you have anything to add next time. Next rule, Rule 23. Rule 23 is about third-party and similar proceedings. That is, leave should be given by the tribunal before a notice can be issued.
OK 啊，係24條啦，跟住20。
Rule 24 provides that the applicant may apply to the tribunal for an order of discovery and production of a document relating to the proceedings from a person for inspection. The tribunal may consider a number of factors. For example, there should be a balance of interest and that the confidentiality of the information before making such a decision. Rule 25 on case management. The tribunal may give directions and to formulate or fix a timetable. Rule 26 on the serving of interrogatories. Leave of the tribunal should be given. Rule 27. The tribunal may direct the parties to file pleadings at any stage of the proceedings as it thinks fit. Rule 28. Now, interlocutory applications must be heard in chambers, and any other proceedings except interlocutory applications must be heard in open court. Okay, Rule 29. Composition of tribunal and appointment of assessor. And that the tribunal may appoint assessors in hearings. Now, will there be any situation in which the president or the deputy president will attend the same hearing, or is it that either the president or the deputy president will do so? Well, this is provided in the ordinance, and in fact, the president may decide the composition of the tribunal for each hearing. So, what combination can we have? Let me find out the provision as soon as possible. Perhaps we can refer to Section 136 of the Competition Ordinance. I'm sorry, it should be Section 145. Section 145 of the Competition Ordinance. There are a number of scenarios. First, it can be presided by the president, or one or more than one member of the tribunal appointed by the president, or one or more than one member appointed by the presiding president. All registrars of the High Court will automatically become, or judges of the High Court would automatically become members. So there are 2 CFI judges who will take up the post of president and deputy president. And the deputy president can also hear a case on its own. Yes, and the third scenario is that it can be done by the deputy president as far as appointment of members are concerned. Right of audience, Rule 30. Now, basically, the right of audience for solicitors and counsel is the same as that in the CFI, in its civil jurisdiction. That is, the party may be represented by a counsel or solicitor or any other person with the leave of the court. I have a question here. There are solicitors and barristers in Hong Kong with experience in competition law, but there aren't many of them. So with more and more cases coming in about competition law, there may be a need for overseas counsel or senior counsel to be engaged in the UK or in other Commonwealth countries. So what should be the procedure to be adopted? Should application be made by the court, as we do now, for leave from the CFI for ad hoc admission of the counsel, or would a direct application be made to the Competition Commission for the tribunal to decide whether the one of the parties may be represented by the Queen's Counsel or a senior counsel overseas? We agree that the existing mechanism should be adopted. That is, the overseas counsel should first get an ad hoc permission or ad hoc admission. So let's say if I want to engage a Queen's Counsel in the UK because he or she has the expertise on competition matters, then I thought I should go back to the CFI for leave. But the judge hearing my application may not be a judge at the tribunal, and the judge may not know whether it's necessary to engage this expert to come to Hong Kong because he is not presiding over the case at the tribunal. So normally, it should be the presiding judge who is in the best position to assess whether we need the overseas expertise. So if we use the existing mechanism, then the judge hearing this application may not know very well whether this is necessary. And very often the case, or perhaps the case should be referred to the presiding judge at the tribunal. Well, this is an administrative matter, and we'll go back and consider your comment and see how we can facilitate such applications. I think the most direct way is this. Let's say if I want to apply for ad hoc admission of a Queen's Counsel to come to Hong Kong, I should apply directly with the President or the Deputy President of the Tribunal to decide whether this leave should be granted.
Can I do that? Well, I have to go back and take a look because this is regulated by the Legal Practitioners Ordinance. We will go back to see whether there is room for that kind of procedure as proposed by you. Mr. Paul Chan, to respond to your question, Chairman, under Rule 31B Roman 2, does it mean it already provides the latitude to take care of the Chairman's question here? Under 31 Roman 2, we don't expect these people to be of the legal profession. These people may be from the trade associations of a certain industry, so they want to represent people in court. We are not thinking of covering overseas lawyers here. Well, you don't have that in mind, but then as we read it here, I'm talking about 31B2. Does it mean that it already means those people can apply? The legal advice we have is that we have to read this together with the Legal Practitioners Ordinance. And that shouldn't be the arrangement we have in mind. But you are not answering my question. I'm not asking about the past, but I'm saying that as we read it as drafted, to respond to the Chairman's question, I think there is the flexibility for this to be done without the need for any amendments. We can go back and take another look. Because under 31.1, we have already provided for the right of audience of lawyers. And when we come to B Roman 2, we should be talking about people who are not of the legal profession. But if you think there is a gray area, we can consider whether there is a need for clarification. We don't intend to allow overseas lawyers to be at the court under B Roman 2. No, the thing is, according to Mr. Paul Chair, if there is a QC or someone who wants to engage a QC from overseas, can he invoke 31B Roman 2 and make an application to the court? And would the Competition Tribunal have the authority to invoke this clause in order to allow that person to appear in court? Well, our understanding is that the leave of the tribunal is required, and the intention is overseas lawyers must gain ad hoc admission under the Legal Practitioners Ordinance before they can do so. Well, that may be your intention, but I think you have to clarify this, 31B Roman 2. Because when the rule is implemented, you must imagine or try to foresee what circumstances will arise. Yes, we'll go back and take another look. Or, for example, if the Competition Commission, if Mr. Mulligan may think that would like to represent the Commission to make an application in a case, maybe it is just the chamber hearing and I'd like to appear as an applicant, can the Commission then engage an in-house lawyer to represent the Commission to make an application? And can that be done under 31B Roman 2? So leave will be granted? Well, yes, this is a matter of interpretation. That is not our legislative intent. If this is how Roman 2 can be interpreted, then we might have to amend it. Well, you may not need to amend it, but Chairman, can I add to your question? I'm not asking you to narrow it down or expand it. I think you just have to clarify your legislative intent. And I would expect that we might be requiring the help of overseas QCs because we don't have a lot of experts in Hong Kong on competition laws. And it's quite probable that once there is a case, we might need to engage overseas QCs. Mr. Paul Chair, well, I in fact don't want this to be narrowed down. I in fact would like more people to be given the right to get legal counsel or legal representative by more convenient and inexpensive means. If I read 31B, I think it is cast in a narrower scope than civil proceedings. When civil proceedings are held in chambers, solicitors can already appear. But if you look at 31B as drafted, you don't even allow that to happen. So on the face of it, you want to promote competition, but you in fact do not encourage competition. Thank you for the question. At the start of the meeting, we explained that the right of audience will be the same for the tribunal as for the High Court. If it is in chambers, then solicitors can appear. And we have taken reference from similar legislation before we drafted this clause. The other legislation does not talk about this in detail. Sorry. I do not have the chance to make cross-references now. Can you not please cite the other rules that should be read in conjunction with this one so that I know only in what circumstances only barristers or counsel having a right of audience before the CFI can appear? Let me see if I can dig up the relevant RHC. Can I please be given some time and respond to Mr. Chair later? The simple legislative intent is to align the right of audience of the tribunal with the CFI. We do not intend to bring in any changes. Well, but reading the rule here, if there is any extension of the RHC or any departure from the RHC, you will always repeat the RHC here. But then this is not done for 31B. Is it that we have to look up the RHC ourselves? Let us do it. We will try to see what RHCs we are talking about and then decide whether we need to clarify this. Legal advisor, I'd like to add 2 points, Chairman. When the administration goes back and consider whether they would have to redraft Rule 30 in any way, I'd like to say that I'm aware that under 30, with regard to the right of audience, I think the view is quite similar to the one of the Hong Kong Bar Association. And may I refer to paper 720-01. In the annex, you have included an exchange with the Bar Association, and para 6 deals with this point. My understanding is that the administration has told the Bar Association, as Ms. Zhang said, that the legislative intent is not to make use of this format to replace the application that has to be made under the legal practitioner's ordinance, and to remove any doubt, they would include in the practice directions of the tribunal how this should be done. Now, if this is the intent of the administration, then it should consider whether that intent is also expressed in the rules and not just in the practice directions. Secondly, I think the judiciary has to clarify another thing. If your intent is for people to go through the procedures under the legal practitioner's ordinance, then how can you consider this in conjunction with 31B Roman 2, and that is if a relevant lawyer has already got the right of audience at the High Court according to the LPO, then for the purposes of 30, does that lawyer still have to get the leave of the tribunal under B Roman 2? In other words, will there be duplicate applications that will be required? Thank you, legal advisor, for the questions. First point, as the legal advisor said, our legislative intent has been the subject of consensus with the legal professional body, and that is to include this in a practice direction. But it seems members still think that this is not clear enough. We will go back and consider whether this should be written into the rules and whether it is sufficient just to include that in the practice directions. And number two, 31B Roman 2, well, I have to repeat, we have already taken reference from the rules of other tribunals, including the Labour Tribunal. And we have in mind people who are not from the legal profession. The legal advisor just said if an overseas lawyer has already got ad hoc admission under LPO, then he will not have to apply again under 31B Roman 2. Well, that's my understanding too, said the chairman. All right. If there are no other questions for Rule 30, we can go to Rule 31. Thank you, Chairman. Rule 31. And when the one party is absent, how the proceedings should be disposed of.
OK， 唔得，請繼續。
32條呢係
Rule 32. When a party is absent from interlocutory applications, how the proceedings will be disposed of by the tribunal. Yes, okay. Continue. Rule 33. Conduct of hearings. The tribunal may direct that there could be submissions in writing. Rule 34. Judgment given in absence of party may be set aside. Yes. Rule 35. Generally speaking, the tribunal can take evidence in whatever means it decides. If there are expert witnesses who need to give evidence overseas, will Rule 35 empower the tribunal with enough flexibility to take care of such applications? If there are expert witnesses, there will be case management hearings in future, and these can be applied for the tribunal to decide. Will there be televised evidence taking? Is that allowed? Thank you for the question. As in civil cases heard at the CFI, if there is a need and with the consent of the parties, we can use overseas television link to gather evidence. There will be a practice direction explaining in what circumstances and what factors have to be considered before the tribunal will allow that to be done. Where is this tribunal going to be? What is the location? we don't have a new court building, but if the rules can be implemented this year, since we are talking about CFI judges, we may set up the Competition Tribunal, first of all, in the High Court. If we have more space, we can consider doing something else. In other words, you may look for another location for the tribunal, not at the time being, because we are going to have CFI judges, and that is why we will situate the Competition Tribunal in the High Court building first until we have new space, and then we can consider situating the tribunal elsewhere. Mr. Paul Chair.
Now, Chairman, I have some concerns. Whether we'd like to follow strictly the rules of the High Court, or are we going to give the tribunal the power to make discretions, and to what extent, and when should the discretions be exercised? Because on the taking evidence, according to the High Court rules, there are different modes of taking evidence, whether written evidence can be submitted on oath or affirmation. But now I'd like to know whether you'd like to follow strictly the rules of the High Court or not. Oh, Chairman, I'd like to supplement. In Section 147 of the Competition Ordinance, it provides that in relation to the taking of evidence, the arrangement at the tribunal will be different. We're not bound by the evidence rules, and the details are set out in Section 147. And based on Section 147, when we consider the mode of taking evidence, we're giving more flexibility. Section 147 sets out the general direction. Of course, there are different modes, but when necessary, if you want to invoke the rules of High Court, you will make it clear which part should apply, which part should not. I understand that the scope is quite wide in relation to the taking of evidence, but in short, will there be any indicative direction? For example, unless otherwise directed by the tribunal, the RHC should apply as a general direction, so that the applicants will have an idea, or whether it's up to the tribunal to determine on the merits of the case. Thank you for the question. On taking evidence, we expressly provide for departure from the rules of the High Court. So not all practices apply here. That's why we have Rule 35. I'm sorry, the question is this. You want to make a difference, the deliberate difference, but sometimes you want to follow strictly the RHC. That's why we want to know your direction, whether each time we need to argue every rule. Well, on Rule 35, we have Section 147, and we have this rule. We understand that when it comes to actual cases, there may be areas of ambiguities, and based on these two provisions, we have prepared the practice directions, and we've also consulted the two legal professional bodies on these details. Well, usually the court will clarify that any such ambiguities are based on the practice directions. All right, perhaps I'll stop here. Yes, do raise questions if you have them. Rule 36 on witness summons and also the payment of expenses. Rule 37 on confidential treatment of information. The applicant may apply for an order to treat the whole or part of the document as confidential. And there are also relevant requirements. For example, the application must be made in writing, and the tribunal will consider the whole case, including the the applicant's interest and the public's interest before making any decision. Rule 38, adjournment. The tribunal may adjourn the hearing of any proceedings that the tribunal thinks fit. Rule 39. Now, parties can agree on the terms of an order to be made by the tribunal. However, for orders made by consent in proceedings under Part 3, 4, 5, and 6, for example, on reviewable determinations, on enforceable orders, because public interest is involved, leave must be sought from the tribunal first. Rule 40. The tribunal may strike out or amend frivolous or vexatious proceedings. Now, there are court rules saying that for frivolous or vexatious claims, there is a different approach by the court to this matter. Does it apply here? I think the chairman is referring to Order 18 and Rule 19 of the RHC. We consider that. We've decided that the provisions need not be included here. And yet this is also important as far as frivolous and vexatious claims are concerned. And we have also drawn reference from the applicable rules in the Small Claims Tribunal, and which are expressly provided. And we therefore agree that it should be included. Okay. Next, Rule 41. The registrar has the power to deal with all the applications dealt with by the tribunal in chambers, and also can transact all business and exercise all authority and jurisdiction. And he also have the power to adjourn an application to be heard by a member of the tribunal. Rule 42. Appeal against decision of registrar to member of tribunal in relation to any appeal against interlocutory decision, determination, or order of the registrar. So the registrar makes a decision or an order, and this would go directly to the presiding judge. Any judge. Could be the president or a judge. Yes, so this is the same as the High Court. Rule 43. Appeal against decision of the registrar to the Court of Appeal, that an appeal may be lodged with the Court of Appeal. And this determination should be final in nature. Rule 44. Now, interlocutory decisions, determinations, or orders made in accordance with Section 1552 of the Ordinance may be appealed as of right by the applicant to the Court of Appeal. Rule 45. An appeal against... I'm sorry, please wait. There's a question on Rule 44. For Rule 44, we wrote to the administration for clarification. Rule 44(2)(g) in English, there is a legal terminology called unless order. Well, the legal profession may understand what it means, but to laymen, they may not understand what is meant by an unless order. In Chinese, it means sort of a time-limited order. So I have done some research. It seems that this terminology is not directly used in any provision in other legislation. So please go back and consider whether this is the case, that this term is not commonly used in other provisions, and whether a definition or interpretation should be provided for this unless order. Thank you, legal advisor. Well, as we pointed out in our response paper, para 22 and 24, we explained what is meant by the unless order. This is made by CFR judges, and we also have the practice direction stating the definition of unless orders. Do we need to provide a definition here? No. Well, this is for members to consider because we note that this term is not used anywhere in the laws of Hong Kong. Of course, the legal profession understands what the unless order means, but we also understand that despite it's not being included in the laws of Hong Kong, we understand the term, but the point is whether it is user-friendly, whether it can be easily understood on reading the text. So, in general, it's harder to understand what's meant by an unless order. So my question is on whether we should use such a technical term in the CTR. I think your comment is very clear. That means a layman may not understand what an unless order means. It is a legal jargon. You should consider whether you could revise it. Yes, we'll go back and consider it. Legal advisor, I'd like to go back to Rule 40. Chairman asked a question, and Ms. Cheung explained to members that Rule 40 is actually modeled on Order 18, Rule 19 of the Rules of High Court, and members may be concerned that my understanding is this. In relation to proceedings to be dealt with, there is a Order 32A, vexatious litigants, and this is based on Rule 27 of the RHC, that is, the court may impose an order for a vexatious litigant to stop filing vexatious or frivolous claims. So this is a bit different from what the scenario in 41. I think the chairman just now asked whether 41A equally applies to the CTR, but as I said just now, the RHC is that there is such a provision in Rule 27 of the RHC. So the Judiciary should also go back and consider Chairman's comments and make a response next time. Yes, I will. I'll give a written response. Please continue. Rule 45. Interlocutory decisions made against a member of the tribunal, or made by a member of the tribunal, and the application for leave to appeal against the decision. Now we've reached Division 9, and perhaps we can stop here because there are other questions that you need to address at the next meeting. Perhaps this is the right moment to stop here, and we can deal with all the questions raised by Mr. Sin, Mr. Chair, and the legal advisor. And at the next meeting, you can give us a response, and we can start with Division 9 next time. All right, we'll stop here. So when will our next meeting be held? Scheduled for the 14th of April. I think they should be available. We'll try our best to answer all your questions. Thank you. Thank you.